Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Good afternoon and welcome to our Zoom argument in cause number 14-19-0091-CV, ExxonMobil Corporation versus Trade Exploration Corp., Brian C. Wagner and Durer Wagner. If counsel please make their appearances for the record.
To please the court, David Gunn for Appellant Exxon.
Your Honor, David Keltner for the appellee, Brian Wagner.
Bill Kirkman for Trade Exploration and Durer Wagner III.
And as you see, it is just me and Justice Hassan today. Justice Jewell is the third member of our panel. He unfortunately was unable to make oral argument today, but will watch the oral argument and still participate in the decision. And with that, I believe Mr. Gunn will go first, and you've reserved 5 minutes for rebuttal?
Yes, Your Honor.
Okay. All right, we're gonna, there we go. All right, we're ready for you.
Thank you, and may it please the court. And it really is good to see you again, and it's good to see my friends on the other side. It's been 8 years since my friend Mr. Keltner and I first argued in this matter to you in mandamus, and 4 years since my friend Mr. Kirkman and I were in the trial. The judgment that we're appealing erroneously goes halfway or partway across the canyon by awarding a partial amount that doesn't square with the verdict or all the years of work that everyone has put into the case. The controlling rule, Rule 301, says that a judgment is supposed to conform to the verdict and to the evidence. This one does not. This judgment departs from those. And I would like to make those 2 points in discussing the verdict and the evidence. And I think in doing so, we can cover the 2 principal arguments that I see in the other side's briefing about what they call allocation and the challenge to the expert testimony. So on the verdict, the verdict point, we're here focusing particularly on question 2 out of the 3 questions. And this will cover the allocation point. That this verdict was not an accident. The form in which the questions were asked, that was the direct consequence of the way the parties tried the case. There was a big clash of paradigms. And frankly, it happened early on. I wanted what I'm going to call a SONAT question, a fallback question. If you look at the Supreme Court's SONAT decision from 2008, that would have asked the jury, if you think this amount was too much, if we didn't persuade you that the amount was right, what amount would have been reasonable? And that surfaced early on. It came back at the charge conference, but I want to stress that it was not an accident at the charge conference. This is not a gotcha or a trap, because the parties had a titanic clash. And if there's one piece of the record I'd ask the court to look at, it's volume 5 of the reporter's record. There's a 20-page colloquy that starts on page 130. I'm not saying the judge ruled there. I'm saying the parties outed this disagreement about paradigms. The all or nothing concept was forcefully and persuasively advanced by my friend, Mr. Kirkman, on page 130, where he said to Judge Burke, it's all or nothing. And the judge said, yeah, thumbs up or thumbs down. They don't get to pick another number. Mr. Kirkman said, that is the law of Texas as it stands. It is the law of this case that the 14th Court of Appeals applied when Exxon took up their issue. Now, I won't go through all 20 pages of it, but you can imagine Judge Burke could foresee, and he said, be careful what you ask for. Mr. Kirkman responded on page 145, it is an all or nothing situation. And I think he foresaw that that could be bad for them. He said, it may be that we don't like it, but that's the law. The colloquy concluded with Judge Burke saying he wanted to study the cases, but he recognized you could submit it as all or nothing and say, if you find it was reasonable, yes or no, and if they answer yes, then the case is over. Well, now if we jump to the, and we get to the,
I'm sorry, did they object? Did the Wagner group object to the form of the question with respect to allocation?
No, and that is exactly my point, Your Honor. This was the way they wanted it. I didn't get my SONAT question. I actually requested it. You'll see it in the clerk's record. That was refused. And the Wagners were very happy at this point. They thought they were winning the case. They didn't want to make any waves about the jury charge. The judge refused my SONAT fallback question. And he said, the settlement's too complex. It's the court's opinion that I cannot reasonably let the jury rewrite the amount of the settlement, which is ironic in light of what he later did. But no, Judge Christopher, they did not object. They did not press allocation as deserving any place whatsoever expressly or specially included in this charge. They argued allocation as part of the reasonableness issue, the all or nothing. They got that trial. That's what they wanted. Now,
Well, if they didn't object to the charge, then don't we measure the evidence by the charges given?
yes,
Okay,
is-
and so then how are they preserving this allocation argument?
it is not preserved. They are challenging the yes answer that the jury returned, but they need to do it in light of this question. And they're trying to smuggle in an allocation instruction that is not in the final version of the charge. I could bring up the draft charges that the parties submitted, but you can see how we got here. And I ask you to look at the definition. There's a definitions page in the charge, the definition of the term MJ Farms litigation. And it defines what lawsuit we're talking about. Because then when you get to the questions, asking about the reasonableness of the settlement, was ExxonMobil's settlement of the MJ Farms litigation, we gave the jury the actual exhibit numbers, was that in good faith, reasonable, and prudent? The MJ Farms litigation is the whole ball of wax. It's defined as lawsuit number 24055 in the 7th District Court of Catahoula Parish. That's what was settled, and that's what you see in the documents. Now they're going to tell you, I suspect, no, the MJ Farms really should have been defined differently. It should have been defined as 24055A, but not 24055B or C, the so-called Missiana and Parawan.
Was there a discussion about that at the charge conference?
No, there absolutely was not, Justice Hassan. And that's our point. So they gambled. They wanted all or nothing. They were happy with this charge. They didn't press for anything about allocation, just a fight about reasonableness. And as both Mr. Kirkman and the judge said in the pretrial, if the jury finds our way, the case is over. That is what happened. It's too late to rewrite this charge to have an allocation aspect that's not in there. And I'm not trying to spring a trap or a gotcha. This was the trial they wanted. They got to argue it fully. Opening, closing, morning, noon, and night. The jury understood it. The jury just didn't find that way. That, I think, if you take this charge at face value, as you should in light of their lack of objection, this is the yardstick. And the parties had a big fight about it. The jury could have permissibly answered yes or no, but it chose to answer yes. And that should be the end of it. Now, that is the verdict piece. There is still the evidence piece. They do have a sufficiency argument, but there's very little to it, in my view. We had 12 witnesses. They called 4. The exhibits are voluminous. I think they take 20 volumes of the reporter's record. We gave the jury the MJ Farms trial transcript, and we proved up a long timeline from the 1994 sale of the properties, the 2006 change of the legal landscape in Louisiana after Corbello, the terribly adverse rulings we suffered in MJ Farms in 2009, the plaintiff's nearly $4 billion damage model, the severance of the Wagners that got them out of the line of fire and sharpened the target on our back, and then our ultimate trial and settlement. I've given you the bench book. I won't take your time walking through it, but I just wanted to give you just a slice of what the jury here not only had before it, but heard day after day. This foundation supports the expert's ultimate answer. We put on an expert. He answered the yes or no question head on, but it's not conclusory. It was explained in 150 pages of testimony at such length that the other side ran out of questions to ask him on cross. So it's a very important swearing match. Both sides had things to say, but the jury made up its mind. and there's just no basis for setting aside that answer.
And there's nothing in the record that would support the lower dollar amount.
No, Your Honor, that dollar amount is a replica of the amount for the other settlement, the smaller case, AgriSouth. And that's the closest thing I can think of now. There's no reason that it should be equal to the MJ settlement. But our trial court conscientiously thought that a number in the middle would be fair and that was a reasonable outcome. And in a bench trial, that might have been the end of it. But in a jury trial, we think that's not permissible. And it's certainly unfair to whipsaw us after I had asked for a fallback question. Say, find a lower amount if this is too much. And then we were told, you cannot have that. So for these reasons, we ask you, undo this JNOV. It's all or nothing, as the other side said, and we ask for a judgment in accordance with the verdict.
Thank you. Mr. Keltner or Mr. Kirkman, who is next?
Your Honor, David Keltner, I'll go next. Let me sec.
Hang on just a minute till we get there we go.
Okay. Your Honor, I'm going to address what Mr. Gunn just talked about in a second, but first, I want to address, I think, the more significant initial problem, and that's this court's jurisdiction and the finality of the judgment. Recent Texas Supreme Court cases, and actually cases from your court, indicate that as a matter of law, this is not a final judgment. Let me explain that, because generally I wouldn't take that position after the court denied our motion to dismiss. Exxon actually says that the motion to dismiss decision was final, but that's strange since they really argued that the court ought to consider all the briefing in order to make that decision. 2 years ago, in the In re Elizondo case, the Supreme Court said that presumptions must yield to clear and unequivocal language. 3 months ago, the Texas Supreme Court in Bella Palma held that if the judgment is clear and unequivocal as to its finality, it controls regardless of any presumption. And in Butler versus Amagi Bank, by Judge McCallie, you were on the panel. The court held that actually the use of the term partial in a judgment indicated it was not final and overcame the Aldridge presumption. That's
But was that case in a bench trial or after a jury trial?
Your Honor, I can't recall whether it was a bench trial. It was after a trial. I don't recall whether it was a bench or a jury trial, candidly.
So it was a trial, not a summary judgment.
It was not, I don't believe it was a summary judgment, Your Honor. It applied Aldridge, which only applies after a trial on the merits. So it was clearly a trial on the merits. And the decision was right, because after all, Aldridge only applies when the judgment is not intrinsically interlocutory. That is the rule. Now, Exxon says that those labels don't make a difference. The Supreme Court has certainly disagreed. In re Elizondo disagreed. Additionally, in re Derridia disagreed as well. And as a result of that is clear. But your opinion in Clark versus Clark last year looked at the same type of thing, applying the Aldridge presumption. And what you said, what was said in that opinion is basically, if it says it's final and it has the Lehman finality language, then we're going to say it in fact is final. So here are the questions I think the court has to ask on finality, and the law requires them. First is, under Aldridge, is this judgment not inherently interlocutory? The answer to that question just undisputably is no, because the judge marked through final and put interlocutory. Does the judgment state that it's a final judgment like Bella Palma, your opinion in Clark, in re Derridia, or in re Elizondo? No, it says it's interlocutory. Does the judgment have Lehman's finality language in it, like Bella Palma, in re Derridia, and Clark? The answer is no, it doesn't. And in fact, even more importantly than that, the trial court scratched it out. I had included it. He took it out intentionally. It's very much like the LAM versus Austin Diamond Exchange opinion from Corpus Christi, where a judge revised a judgment to take out finality language, and the court said that was conclusive.
Mr. Hill, what are the issues that are still pending in the trial court? What makes this an interlocutory judgment in your opinion?
Well, first off, the judge, and I'm holding up the copy of the judgment, the judge says it is. He says it's interlocutory. He directs the parties to do calculations on interest calculations and other types of things. There was
interest calculations don't have to be in a judgment.
They don't necessarily have to be, but he wanted them in the judgment and notified the parties of that. We did that. The other side did not. The other thing that was very important, and Justice Hassan, to your question, is the other issue that had come up was a settlement credit. And since there's now no confidentiality concerns, that was a huge issue because it was $10 million. And the parties were disagreeing. Everybody agreed it applied. And let me also note that Exxon now says that it should apply and this court should apply it. But the truth of the matter is that was still a matter of concern.
But he struck out the settlement credit. So he made a ruling on that.
Well,
he didn't say settlement credit, are we going to use present value or the full amount, which is my understanding is the dispute.
Well, initially, Exxon made precisely that argument, and then in its later brief changed and admitted that we are entitled to the settlement credit. And
but I mean, I'm talking about the trial judge did not leave it blank. He struck it, indicating that he did not believe there was a settlement credit.
I don't think you can draw that conclusion given the fact that he had directed more work to be done before he entered a final judgment, which he intended to do, and said so in the judgment. And in a hearing that we had on the last day of the year, right as he was leaving office, unfortunately, although we were told a court reporter wasn't there, it's not recorded. So I think really from our standpoint, the big question is, does the judgment state in clear and unequivocal language that it's interlocutory, not final? It does. That satisfies Bella Palma. That satisfies your decision in Clark, and it is not final. And there are consequences to this for us, Your Honor. We did not have an opportunity to do a motion for new trial that would have preserved other types of errors we have not been able to make, including insufficiency arguments and the like. Now, that is it on finality. The real truth of the matter is
you could have filed the motion for new trial.
Oh, we did. But okay. It was after the notice of appeal was filed and we knew that they were for the first time taking the position that it was a final judgment. But Your Honor, my point to you on this is this. Just like in Butler versus Amegy Bank, the Aldrich presumption was rebutted, and that's important. Let me turn to segregation and the allocation issue that my good friend David Gunn has talked about. We have a completely different opinion of this. Let me explain why. Throughout the trial, we had talked about allocation and the failure of Exxon to put on evidence of allocation. They didn't. And in fact, actually their general counsel and the lawyer handling this case said they couldn't allocate, didn't allocate, made no attempt to allocate. Allocation is different than reasonableness. And if you look at the question that Mr. Gunn submitted, it may have been different than an all or nothing issue, but it had nothing to do with allocation. It only had to do with reasonableness.
Well, did you object? Did you object to the question that it didn't have allocation in it?
No, we didn't object because that's not how that is done. Just like in Tony Gullo, which was a trial on the merits. And just like the other cases it cites regarding final trials, there's no objection to an allocation question. The truth of the matter is the plaintiff has the burden to allocate damages between those recoverable and those not.
Well, if we are likening it to attorney's fees, that's a new trial. It's not a JNOV.
Your Honor, we agree with that, and we believe new trial is the remedy. And if you look at our JNOV, we say that specifically to the trial court. That was one.
But to preserve segregation of attorney's fees, you have to object to the jury charge on that basis.
Well, we didn't object to the jury charge. I will say that is true. We also pushed back. We did bring to the trial court's attention the failure to allocate both before and after the charge conference, and that was no secret. Your Honor, as you know, the burden in this case, and from your Home Comfortable versus Cooper case from 2 years ago, the burden's on the plaintiff to allocate. They made no attempt to do that.
That's
Now,
an insurance case? The
uh,
allocation?
it is not an insurance case, Your Honor. And by the way, the one other thing I want to, I'm glad you brought that up. We have another disagreement I'll spend the last seconds on, and that is the applicant.
Could you tell me the name of that case again that you say is not an insurance case?
Yeah, I think it's Home Comfortable versus Cooper.
Thank you. Go ahead.
All right. And final, we have one other disagreement, and it's on the Adafina and Block line of cases. They say they are relieved from proving reasonableness and suggest even allocation under those cases because we did not actually come in and indemnify. That is not the case. Those cases are insurance cases. They don't apply in a commercial indemnity context. We briefed that in detail for you. I think one of the biggest things on that you will see is, and I'll do this very, very briefly, it is Nancy Atlas's opinion in the Marathon GH Holdings case, which indicates that insurance law on these issues and commercial indemnity are completely different.
Well, that would be, if there hadn't been a legal determination, that'd be a fact question anyway, wouldn't it?
Which one, on reasonableness?
No, whether you waive the right to contest the reasonableness by your failure to defend. That's a fact question, isn't it?
No, that is a legal question, so say the courts. And the issue, and that is the important issue under Block and Adafina. And the truth of the matter is that obligation on reasonableness is their obligation, not ours. They had the burden of proof on that. We at 42 and 43, and I'll be very careful, I know I'm over my time. We cite cases to you on commercial indemnities. Amaretta Hess by Wanda Fowler from 2000 is probably the best example of that. But I'll just say this one last thing. If this court applies the Adafina and Block cases to say there is a collateral estoppel on reasonableness and allocation, it will be the first court in Texas to have done so.
Okay, thank you. Mr.
Thank you, Your Honor.
Your Honors, I want to first address the question of whether there was legally sufficient evidence of reasonableness to support the judgment. I think it's important to put into context the fundamental basis of how we got here. The court, I'm sure, knows that there was a previous opinion by this court that essentially prevented us from obtaining Exxon's internal documents that everyone agreed, that is, no one disputed, literally set forth the reasons why Exxon settled this case. Now, given that, this court's previous opinion basically said that Exxon assumed the risk of being able to prove facts that rendered it liable to the plaintiffs, as well as the reasonableness of the amount that it paid, and that had to be done by expert testimony. So we started with that basis at the trial. That is, you got to prove that this amount that you paid was reasonable, A, and B, you have to do it through an expert witness. Exxon tendered a man by the name of Mr. McLaughlin. And Mr. McLaughlin's testimony is set out in detail in the record. I respectfully suggest that almost the entire basis of his testimony was that they had a demand of $3.9 billion with a B dollars. Now, understandably, that's a lot of money. However, in and of itself, that cannot possibly justify the reasonableness of a settlement. Because, of course, anybody knows all some plaintiff would have to do is make a very high demand, put an expert on the witness and say, well, because he had such a high demand, I had to pay a lot of money. So it is ipsi dicta in and of itself. Now, when you pile on top of that the fact that the expert witness, Mr. McLaughlin, never testified as to any comparable settlement, Your Honor. This is despite the fact that on cross-examination, it was determined that he had some knowledge of over 30 of them. And when the court reads—
He testified about verdicts? He testified about verdicts?
He testified about published cases, cases had to be tried, no question. But when the court reads the Christ case that we cite on page 10 of our principal brief, it says unambiguously that the key element of testimony on the reasonableness of a settlement is other settlements. And the fact that he did not put forth any testimony about the reasonableness of settlements doesn't support, I mean, it gives absolutely no support to the jury's findings of 57.5 because he didn't have any testimony about it. Now, let me tell you another thing that is critical that establishes how this testimony of Mr. McLaughlin can't possibly be reasonable. I know this court knows that there must be a demonstrable, reasonable, analytical basis to make an opinion. It's got to be based on facts. Those facts cannot be inaccurate. Those facts can't be in dispute. And remember that his testimony at trial was based on what is now clearly an inaccurate fact, and that is who owned the servitude. I can tell you, as the lawyer that was involved in trying this case, there was not a more important discussed fact than Exxon standing up and saying, oh my gosh, we got this big, huge demand that has been made to us, and we own the servitude.
But
And
Mr.
we're gonna
Gershman,
get
that judicial decision came out after the trial. Correct?
That there was a decision by a Louisiana court after the trial that they didn't, but
Right.
it doesn't change the fact that that's an inaccurate statement, and there was no basis for him to say that. And when
Other
he's
than a ruling
testified,
by the judge that Exxon did own the servitude, correct?
not a ruling by this trial judge, no.
No, in Louisiana.
There was a ruling that was reversed. And it's the subject of, I mean, it's all set forth in our
But at
section
the
on the
time
race.
of the settlement, that was the ruling of the judge.
There was, that's correct.
Okay.
But that they was still subject to appeal. It was still an open question. So
And
there
that was
really
all
hadn't been-
discussed in the trial, right? That it was still an open question.
No, I'd have to check the record. I don't believe that's accurate. The point I'm trying to make is he made this unequivocal statement that they owned the servitude when it was not true. I see my time is up.
Thank you. All right, Mr. Gunn, rebuttal?
Your Honor,
Hang on just
I
a
did-
minute. I don't see you yet.
let's try.
There we go.
My apologies, I'm learning.
No, that's okay.
No, Your Honor, the only point I think worth mentioning is on jurisdiction. And of course, I'm available to answer any questions the court has, but the parties have covered the merits exhaustively. On jurisdiction, we covered it in a 13-page response to the motion to dismiss a year ago. And we told the court candidly, we understand there are arguments both ways, but we think the better view is that the judgment is final because it actually disposes of all claims and parties. And the court asked the other side that question, what is left? There's really nothing left. I won't rehash that debate. What I would say to the court,
Mr. Gunn, if we stick with our opinion that it was final and not reverse it here, it worries me that lawyers might look at this interlocutory, judgment that says interlocutory and says, please give me some more information and not appeal.
right.
I mean, that's what worries me from a jurisprudential point of view.
I get it. I don't know what to say, Your Honor. When that thing came out, that worried me. That's why I appealed it. When the judge signed his judgment as I was getting ready to go to a New Year's Eve party, his term was expiring. I took a look at it and thought, that's a live hand grenade with the pin pulled. I think it disposes of everything. And yes, there are going to be close calls. That's where I think the presumption of finality after a full trial tips the balance. The point I wanted to make in rebuttal is not to tell the court my views about jurisdiction, which is an issue you deal with every day and you're the experts on. It is just to say, if you conclude that something is left to be done, we would ask you, don't dismiss this appeal and make us start over.
Okay, but what about, okay, when did Judge Burke sign this and when did you file your notice of appeal?
He signed it the December 31. We filed our notice of appeal on day 30.
So the Wagner Group did not have the ability to file a motion for new trial.
They had 30 days to file it. They had.
Oh, but they didn't know that you thought it was final until day 30.
I don't work for the Wagners.
I know, but I'm just talking about in terms of potential problems.
I hear you, Your Honor. I can write a motion for new trial from a 3-question verdict in 5 minutes. That I can file it. I can have it on file in half an hour. I mean, what? There was nothing to complain about. Their motion for new trial, you've seen this record. There is nothing to press. They don't have any meaningful factual insufficiency points. There are no trial error. They got the trial they wanted. They were in high cotton. Every day was a walk in the park for them. We were getting clubbed like baby seals and somehow got the verdict. They have nothing to complain about. I mean, truly, there's really nothing they can put in there. If they want to have 3 lines in a motion for new trial, they can say, the answer to question 1 is supported by no evidence or insufficient evidence. Same for question 2, same for question 3, respectfully submitted. That's all they have. If they had pursued that, and if for some reason the new judge had said, I'm granting it, let's retry it, we would come to you on a mandamus and say, can we please have your opinion on that? I think that's a bad grant of a new trial. And
But isn't there expert testimony argument also one of sufficiency, not no evidence?
no, I think it's no evidence or nothing. I think it's no evidence or nothing. They're saying our expert gave conclusory ipsy-dixit testimony. It's all or nothing. I mean, I don't know how you do a Pool versus Ford Motor Company weighing. They had expert testimony. We did. They just disagreed about a yes or no question. Seems to me there's no way and even if they had an insufficiency argument, it takes all of 10 seconds to write that in a motion for new trial and file it. I mean, they had 30 days to file a motion for new trial. They didn't do it. So, I mean, I'm sorry, but that's really on them. They were not deprived of any opportunity.
So in that time frame, was a new judgment sent to Judge Burke?
I don't think so. No, I think not. I think the one he signed was the last one that we had. And
He was off the bench the following day.
yes, exactly. He was off the bench. This was done on his last day in office, and we felt like that actually disposes of all claims and parties. So we're going to the next court. And with that, I have nothing further unless the court has additional questions.
All right. You have anything further? All right. Well, thank you very much. Thank everyone for your arguments. We really enjoyed it. The briefing was excellent, and the case is submitted. Thank you very much.
Thank you, Your Honor.